Hello and welcome to the program on 2016 Hot Topics in Bankruptcy. On behalf of Aurora Training Advantage, I would like to thank you for joining us. Your guest speaker today is Franklin Drake. Mr. Drake concentrates his practice in the areas of creditors' rights, creditors' bankruptcy, and commercial litigation. Mr. Frank has worked with credit unions, banking and financial institutions, consumer and commercial lenders, and student loan agencies to enforce contracts, minimize losses, and fight fraud. As federal regulatory compliance has become increasingly complex, he also assists leaders with difficult compliance issues. Mr. Drake has taught classes on bankruptcy and commercial law for the Indiana Bankers Association at Butler University, the National Association of State Chartered Credit Unions, supervisors in various states, credit union leagues. He also served as speaker for several student loan lending agencies, credit unions, and state and local bar associations. Questions can be entered in the control panel, and as many as possible will be answered at the end of the presentation. Enjoy the program.
Good afternoon, ladies and gentlemen. We're going to have about an hour and a half or so together today, and we're going to talk about the topic of bankruptcy and its impact on consumer lenders throughout the country. There are two flavors of bankruptcy that we're going to concentrate on primarily, Chapter 7 and Chapter 13. To a very limited extent, Chapter 11 enters into consumer lending primarily because consumers, when they bankrupt, don't normally file Chapter 11. So that you know something about me, I am a lawyer, and I spend a lot of my time giving a lot of legal advice to a lot of different forms of commercial and consumer lenders all over the country of all stripes. I'm going to assume that most of my listeners are going to be people who are part of the consumer lending industry or are part of the business world and are in circumstances where individuals who owe them money file bankruptcy on them. If you are looking for bankruptcy advice as to whether or not you should file bankruptcy, I guarantee you will not find it here. I represent creditors and have done nothing else for the last 38 years, and so I have a very one-sided attitude. I have a very cynical attitude, some of my colleagues tell me, who practice the other side of the bar, because they consider themselves to be doing the work of the angels, and they consider that I'm a servant of capital. I am a servant of capital. I'm licensed in 3 states. I'm licensed in the great state of North Carolina, where is my home and where I'm speaking from. I'm licensed in Kentucky, and I'm licensed in the great state of West Virginia. None of them is probably your state, but it doesn't make any difference. I practiced bankruptcy law, which is a federal statute, not a state statute, for several decades, and it is the same, largely the same nationwide. The topics and the principles that we're going to talk about will apply to you and the bankruptcies that land on your desk, regardless of where you reside. But it's important to me that you put your questions to us all, if you have any, during this program. When I speak, and I speak several times, dozen times a year around the country, to live audiences, I encourage people to put their hands up during the presentation. Don't wait to the end. If I say something that does not make sense or that slips past you, put your hand up. Make me explain it till you do understand it, because I guarantee you, if you've got a question, there are 2 other people in the audience who don't have the courage to put their hand up like you do. So ask your questions. I'll do my best to visit the chat box here periodically as I walk around my office waving my arms as if I'm in front of a live audience and do my best to answer them. Now, if after this program is done, questions emerge in your mind or unclarities become evident or otherwise, on the opening page you will find my email address, and I invite you to shoot me an email, and I'll do my best to answer it in as great a detail as necessary without sending you a bill, provided that we stick to the topic and it's not state-specific in a state in which I'm not licensed. Now, in addition to the 24 or so PowerPoint slides that we're going to talk about, I've also provided the sponsor with a written outline, and that written outline in the classic outline style of Roman numeral 1, capital A, Arabic 1, and so forth, the way we all learned it in the 6th grade, contains a whole lot more material than you're going to find on the PowerPoint slides. There's nothing on the PowerPoint slides that's not in the outline, and there's plenty in the outline that isn't in the PowerPoint slides. I recommend above all else that if you want to download and print something or download and capture something electronically, let it be the outline, never mind these slides. These slides are just talking points and not much more than that. There's going to be many a question that can be answered by reference to the outline going forward. There are also citations in there and the names of statutes and so forth that your own local counsel may want to know about. Going forward, you should know that there are some things that as a lender in bankruptcy you can do for yourself and that you do not need a lawyer to do for you. And there are some things which you cannot do for yourself. If you are a consumer lender who is accustomed to pursuing defaulting debtors in small claims court, you've got plenty of experience of going to court by yourself without a lawyer in tow on relatively small balance accounts. That saves you money as long as you end up walking out of there with a judgment. A lot of creditors get the same idea that they can behave the same way whenever a debtor files a Chapter 7 or Chapter 13 bankruptcy. It's less true than it is in small claims court. There are sometimes a few things you can do for yourself. We're going to talk about them. There are other things which your lawyer is going to have to do instead. Okay, let's advance the slide here. What we're going to talk about in three general areas are the common causes of the delinquency, the warning signs of bankruptcy on the horizon, and the effective strategies that you can adopt in an effort to minimize your loss. Now, you have to understand the fundamental philosophy of bankruptcy in order for any of the rest of this to make any sense. The first thing you have to do if you're going to understand the way the law works is to put aside any hope of justice. You are not going to get justice and you're not going to get treated fairly in bankruptcy court if you are a creditor. The purpose of bankruptcy court is not to do justice. The purpose of bankruptcy court is to allow individuals who owe money to shirk their debt. The purpose of bankruptcy court is to allow people who have made promises to pay or perform to shirk their promises, to fail, to not pay, to welsh. That's the reason that it exists. And if you have a fundamental problem with the existence of bankruptcy, I guess my only suggestion to you is take it up with the Founding Fathers, because the principle of bankruptcy and the statutory right to create the bankruptcy court system exists in the Constitution. This country was founded by bankrupts, by individuals who could not pay their debts, by debtors, prison inmates, etc., who were brought to this country on this side of the ocean and dumped on the shore and left here, just like in many respects Australia was settled. For the first 150 years or so of American existence, people did not file bankruptcy despite the fact that the law might provide for it, because it was considered a social stain on yourself and your family to do so. You didn't file bankruptcy any more than you got divorced. In the old days, people didn't get divorced, they just shot their spouse or ran off. In the old days, people didn't file bankruptcy, they just loaded up into a covered wagon and moved west. That's a lot of the reason why westward expansion happened the way it did. There was no effective means of filing bankruptcy, escaping your debts, and getting a fresh start, so people would just load up and bug out. That worked very well until the frontier closed in 1890. Once the frontier closed, Congress had to adopt a new system whereby people could get a fresh start. People with too many debts could escape their debts, escape their creditors with some basic minimum so that they could restart their lives and try again. And so in 1898, Congress came up with what was called the Bankruptcy Act of 1898. And it provided for the basic form of Chapter 7 bankruptcy that we're most familiar with today. It's a straight bankruptcy where you just dump your debts and you start over again. That bankruptcy law remained the law of the land until 1978. From 1898 to 1978, the Bankruptcy Act was the law, and in 78, Congress changed it. They threw out the old act and they adopted what is today called the Bankruptcy Code. With a series of amendments that have followed since 1978, we remain under the Bankruptcy Code. And there are two forms of bankruptcy under the code that are most common for consumer borrowers and consumer lenders. Chapter 7, straight bankruptcy, and Chapter 13, which is so-called repayment plans. A lot of people confuse the two, and they think that one is the other or that 13 is not bankruptcy. It is, in fact, a form of bankruptcy. Common causes of delinquency that exist today are the same ones that have existed in the past. Usually it amounts to job loss. I don't know if it's been true in your state, but in our state, a number of plants in the last 10 or 15 years have closed as a result of fair trade agreements. They've all moved to other parts of the world and are probably never going to be back. Sometimes individuals get used to living on overtime, and when the overtime goes away, they hit a rock. There are plenty of people in the world who live every dollar they earn, regardless of how many or how few it is. By the way, this CU means credit union in the slide. It applies equally to banks, it applies to credit unions, it applies to finance companies. It's all pretty much the same. Selected employee groups, whenever a given plant closes, sometimes that plant constitutes a significant portion of the entire local economy. And when that plant closes and moves to Shanghai, number one, it's never coming back. And number two, the individuals who were making a nice living working on their assembly line jobs lose those jobs, are never reemployed at the same level, and suffer a permanent economic downfall. The result is that credit unions in that local area and banks in that local area suffer just as much as the members do, just as much as the depositors do, because they can't pay and they don't get their money back. Uninsured medical expenses are another very common cause. A family disaster, not an economic disaster, but a medical disaster will frequently wipe people out. And the result is that although the debt is unsecured, credit unions and banks and finance companies typically find individuals who are otherwise paying as agreed suddenly filing bankruptcy out of the blue. The reason is not job loss. The reason is not divorce, although those are very common. The reason is uninsured medical costs. One hopes perhaps that may not be true so much in the future. That remains to be seen, but it certainly is now. Frequently, individuals who have problems in their lives end up squandering their income as well. Substance abuse will do it. Alcoholism will do it. As we politely call it at home, side sugars will do it. The result is the problem becomes acute, and they end up resorting to bankruptcy after they take the cure. After they've gotten clean or gone through rehab, the next thing they do is they file bankruptcy to try to get rid of the debts that they incurred at a time in which they were befogged. Divorce or separation, loss of one's cohabitational partner, all of those mean that income goes out the door. And frequently there's no particular warning, although sometimes some of the signs can become more obvious than others. An otherwise properly paid account which begins to become chronically later and later is one sign. An inability to reach an individual on a cell phone because he moves without leaving a proper forwarding address is an obvious other one. A lapse of insurance coverage on collateral is clearly another one. If he's not paying for collision coverage on his car, or he's not paying for casualty coverage on his house, and you're secured by either one, we've got a deep financial problem going on. Any one of those should be enough to make you suspicious that you're about to receive a sudden notice of bankruptcy. Now, with regard to those notices, I recommend to you that every one of you out there, if you make any level of loan to consumers at all, or if you have any kind of consumer risk accounts, and especially if your business has more than one form of mailing address, a post office box, a series of post office boxes, a series of branches, a number of different street addresses, you're a bank or a credit union that is merged with other credit unions, and you are the survivor, and the old institutions' addresses are still out there. They're now being operated as branches or otherwise. Every one of you needs to take at least the following two measures, at least one of the two measures, to try to enhance the speed with which you receive bankruptcy notices. You either want to sign up with the National Creditor Registration Service, or, and that's assuming you want to behave as if you were in the 20th century, or if you want to behave as if you're in the 21st century, you sign up for what's called electronic bankruptcy noticing.